My lady, my lords, we were just looking at the embedding sustainability document in the appendix part 2, volume 7, and I was just going to turn up page 2417, and only a few more passages that I wish to show you. But this is under the heading committed to minimising our footprint, and the first substantive paragraph says that we're committed to ensuring we comply with our international best practice, with our processes mapped against international standards such as the International Finance Corporation, that's part of the World Bank performance standards, which are applied to the entire life cycle of our operations. And then under environmental risk mitigation, in order to manage environmental impacts, we have identified key areas where the biggest impact and risks are associated. These are water, biodiversity, energy management, land management, air quality and waste. The group and our subsidiaries have developed a plan to effectively manage each of these areas as detailed on the next page. And then under environmental management, it forms a key component of the Vedanta Sustainability Framework and a complete set of supporting environmental policies, management and technical standards finalised in 2012 and rolled out across the group. We continue to augment our processes through the ongoing development of guidance notes and the implementation of an extensive supporting training framework. So it's at least arguable on the face of this passage and others that waste management and the impact on the environment is a particular area in which the parent company has taken upon itself to exercise, we would say, at least arguably, control through the steps that it's identified. And this is another reason why we submit that my learned friend's argument that the type of liability that we seek is liability for falling off a ladder misunderstands the nature of the case that it faces. It's a particular area of control that the parent has taken upon itself to exert over the subsidiary in the area of direct relevance to the claim that we bring. If we could just turn over to page 2419. We strive for zero environmental incidents and have a robust internal process, including categorising incidents according to severity for managing any incident that does occur. Subsidiary businesses monitor, report and investigate all accidents with the aim of applying lessons learned to prevent recurrence of similar events and share learning across the groups. That's something the parent's putting in place. Environmental incident management. We continue to develop awareness across the group. First paragraph, training is provided. Third paragraph, Vedanta's internal system for incidents categorises them according to their severity, with the Sustainability Committee reviewing category 4 and 5 incidents, the highest categories, on a quarterly basis, and all incidents are reviewed at group level on a monthly basis, headed by the Group Head of Environment. The higher category incidents are again reviewed both at the Subcommittee and Sustainability Committee. Page 2421 over the page deals with the approach and performance in key environmental areas. And we see under water, in the second paragraph, we also take very seriously the obligations we have to the communities within which our business operates, and it's essential they have access to clean drinking water. We accept that it is our role to manage our water usage in a way that protects and indeed, where possible, enhances local health, industry and the environment. Skipping a paragraph, we turn directly to Zambia. Due to the high water table in Zambia, our KCM subsidiary withdraws and dewaters a large quantity of water from its underground mines. Approximately 60% is discharged into the nearby river, with proper treatment, ensuring that the wastewater quality is within statutory prescribed norms. The court may wish to mentally cross-refer to our pleadings where we set out the Zambian regulators' findings into, in fact, what the discharges contain, which is many hundreds of times over the statutory prescribed limits. Then under water management, we use water in mining, smelting, refining, power plants, sources like groundwater. None of the water sources is significantly affected by the withdrawal. While some of our water-dependent are located in environments where access to water can be a challenge, we have a consistent approach to water management across the all group subsidiaries and a clearly stated water policy. That one is available, it said, on the website. And then one paragraph down, maintaining aquifer quality is the core aim driving our water policies and standards. A few lines down, our environmental policies and management standards are mandatory across the group and address contaminated land management concerns. The standards require operations to prevent contamination of land and water, and then we can see one of the most significant, they list some of the significant areas, including water and waste. That's the key passages in this document. And to return to the point, responding to a point made by my Lord Wilson, as to the purpose for which I'm relying on in current purposes, just taken at face value, it's to the purposes of demonstrating the arguability of the question of duty, the nature of the control, why it is said. I can well anticipate, if the facts set out reflect a company with good corporate governance, that this may be material relevant to breach in due course at a trial. It may be said on behalf of the parent, everything we did here was trying to create the best possible standards that we could, and it could be said on a reading of this that this is what it reflects, but that's not the purpose for which I'm relying on it at present. I may have a lot to say about that at a trial, depending on the evidence. But the purpose for which we're relying on at the moment is purely to the question of duty and the arguability of duty. And it goes to show, we say, at the very least, the arguability of our case. This is the parent company exercising a high level of degree of control. That of itself, we say, suffices at this stage of proceedings. It also, if I may respond to a point raised by my Lord Hodge, tells us something about the use of mandatory in their own terms policies. Because in the areas that are absolutely key, it appears to be at least arguable that Vedanta had in place mandatory policies upon which the subsidiary were forced to rely. And as I've said before, we don't know whether those policies are good or bad.
Yes, so are you saying if the policies were good, well, and the subsidiary didn't carry them out, there mightn't be breach on the part of the parent, but if the policies were inadequate, and the subsidiary was required to carry them out, in that context, you might visit liability on the parent.
Yes, I would seek, my Lord, at this stage to try and have it both ways, actually, at least from the arguability perspective. I would certainly say that if these are mandatory policies that the parent is putting in place and they are defective, and that is not an unreasonable proposition to advance in circumstances in which we know there are policies, or be it not the content, and we know there has been, or at least on our case, which is accepted for the purposes of this application, there has been tremendous, I use that pejoratively and qualitatively, pollution of the waterway. So something, we say, has gone horribly wrong, and in circumstances in which we know there are mandatory policies, it is certainly reasonable to posit that that might be, the answer to that might be found in the policies themselves. So we certainly seek to have it that way. But we also say that there would be a duty, because of the nature of the control, because it is mandatory policies upon which reliance is being placed, it is certainly arguable that there would be a duty, even if those policies were on paper sound, for the parent to enforce. And indeed, it tells us it has structures in place to review and enforce. So it may be those structures are deficient. It may be there's a freestanding, as there was in Chandler, obligation to enforce. Because the court will recall in Chandler, there were no policies put in place by the parent company, but yet liability was found, because there should have been. So if you can establish, as Chandler says, a duty because there should have been policies, the position may be thought to be a fortiori, where you don't enforce policies that you mandate.
Might not that be using Chandler as a statute? Because the facts of Chandler, as I recall them, are that in a sense it was liability because of inheritance of the parent's way of operation in the very same premises by the subsidiary. And it was the fact that an unsafe system was put there by the parent and then inherited that created the obligation to do something.
Well, my Lord, that was a factual feature of Chandler.
Yes.
We would respect to say that can't be identified in Chandler as the key active ingredient. But I entirely accept the force of my Lord Briggs's point that there is a danger in treating any of these previous cases as statute. Although it may well be, as anticipated in the passage I took to you in Lord Hope in Three Rivers, that if a case such as this goes to trial and the ambit of the duty is determined by reference to evidence, it will become possible, or there will be certainly greater clarity in the cases that follow, as to when something is arguable, when it is not arguable. But we haven't had a case quite like this on the facts before the court before. That's the sustainability document. Rather than just show you additional documents from Vedanta that are published, many of which we cite in the pleadings, they're also in Mr. Day's statement, can I just show you some different types of documents rather than just loading you with more of the same? I'm just going to show you briefly a KCM document. So that's a Vedanta document. So this is a KCM document, but it again gives us an insight to the relationship between the two companies and just a bit of history. I won't spend long on it. You'll find it in Appendix Part 2, Volume 8, Tab 87, MS 2671. Again, this is really more by context, to provide some form of context. It's heading Vedanta's commitment to Zambia, and it gives you some background as to the relationship between the two. It's a Konkola Copper Mines PLC publication. It refers to Vedanta's commitment to Zambia, and it is, we say, clear on a plain reading that many of the references are to Vedanta PLC, not to KCM. Vedanta Resources PLC is identified under the company overview, which identifies that Mr. Albanese is appointed the new CEO of Vedanta and also the chair of KCM. Of course, I don't say that mere crossover in personnel at board level is determinative of anything, but it is not irrelevant. It then, under background to KCM, gives the history as to when Vedanta came in at a point at which Vedanta was facing real difficulties. And if we turn over the page to 2672, we can see the heading that Vedanta's investment came at a difficult time, and then on the opposite column it was in this environment that it came in and provided a Vedanta PLC the full commitment to recapitalise, commitment to maintain and increase employment, provide local business development, commitment to social services and support for the community. And we can see something as to some of the support in the rest of the document under Vedanta's continuing support to KCM. That sets down the very significant financial support. It talks about the management expertise that Vedanta have brought into KCM. On the next page, under capital investment and production, it tells you what that money has gone to. So since Vedanta's acquisition of KCM, we have invested about 3 billion, representing the largest capital investment in Zambia. Now that can only, we say, sensibly be read as Vedanta PLC. Our investment in KCM, which hopefully proved my point, has been in the form of new assets, the revamp of existing infrastructure and the increase in reserves. And we've already extended the life of various mines. And then you can see, second column towards the bottom, community development and social responsibility. When Vedanta took over KCM's operations, we, PLC, not only took over responsibility of assets, but continued inherited social responsibilities. So that's a KCM document. So the two documents I've shown you so far are outward-looking. They're publications to the world at large, although no doubt for the attention of those investors who they are seeking to attract. Could I just show you an internal document, which is the management agreement between PLC and subsidiary? You'll find that in Appendix 2, Volume 6, Tab 65, MS 1875. At 1875, if I could just show you Clause C in the recital, so you can see what it's about. It's a condition to completion that the company and Vedanta enter into this agreement whereby Vedanta agrees to provide or cause to be provided, and the company agrees to purchase the services, and the company may request and Vedanta may agree to provide or cause to be provide, whereupon the company agrees to purchase the additional services. Um, 3.1 Oh, I'm sorry, 3.1 under services at 1880. The company hereby retains Vedanta to provide, and Vedanta shall provide itself or through the Vedanta Group, excluding the company, its know-how, and I'll show you the definition of that in a moment, and the management, operational and technical functions and the services set out below for in connection with the facilities, geological and mining services, employee training services, metallurgical consulting services with respect to the facilities, moving to E, assistance with management systems and technical and information technology and other services. F, strategic planning, business and corporate strategy, and planning including project development and management. G, consulting services in connection with procurement of supplies, material, equipment or services required for this facility and associated logistical support. And then if we can just turn back to 1877, at the bottom of that page, you can see the definition of know-how, which means all proprietary, technical and other information and trade secrets, and all non-proprietary, technical and other information relating to the services owned by the Vedanta Group. We can see that at 4.1 there's an entitlement of the subsidiary to request additional services outside the scope of this agreement from Vedanta. We can see that in addition to the fee that I'll show you, at 5.1, the company reimburses Vedanta for any expenses reasonably incurred in the connection with the provision of any services or additional services. And then this at 6.1, which may be thought material. Vedanta shall perform the services and additional services with that degree of care, skill and judgment normally exercised by companies in the mining industry when providing services of a similar nature. Of course, we remembered that the evidence submitted by Mr. Kumar and Mr. Nadole was to the effect that Vedanta is not it's not in the business of mining. It's essentially a passive holding company with some very loose structural oversight. It said that, of course, this is an agreement for a fee of £1 million, dollars, I beg your pardon. That's not necessarily what's relied on. It's the scope and the nature of the obligations in the management agreement, and see also our written case between paragraphs 132 to 4, where we refer to a recent case before the commercial court when KCM was again before them, where in breach of a settlement agreement, KCM had been paying very significant figures to Vedanta for a range of fairly unparticularised items. So that's 132 to 4 of our written case, MS 323.
MS.
I'm so sorry,
MS.
323.
Thank you.
And you might, for your note, compare and contrast those clauses in the management agreement with the evidence of Mr. Kumar that Vedanta isn't a mining company. That's paragraph 8 of his witness statement, core volume 4, tab 32 at MS 1147. So that's another a type of evidence that was before the court. Can I show you another type of evidence, which was the witness statement that we've managed to obtain from a former member of management? We can live with Mr. Gibson's classification of middle management. For our purposes, it doesn't matter. He's a Mr. Davis Kalenga. You'll find his witness statement in core volume 5 at tab 51, MS 1607. I'd ask in due course if the court would indulge us by reading the statement, but in particular, could I ask you just to read now paragraphs 8 to 13, starting at MS 1609. would invite you in due course to consider whether the mere fact that Mr. Ndulu is senior to him in the defendant's organisation means that Mr. Ndulu's dismissal of his evidence, or Mr. Kumar's for that matter, is so authoritative that this evidence can be dismissed at this stage. Finally, can I show you one other source of evidence, which, to be very plain, is not a source that I would be relying on at a trial, but it is a source that we say is legitimate to look at this stage for this test, which is the decision of the Irish High Court on an interlocutory application, only because it just gives us an insight into what may be the actuality of control operated by the parent company. That's a decision in a case called Elms, which you'll find in Authorities Volume 13 at tab 126, MS 6835. You can get a sense at 6836 from the opening paragraphs of Mr. Justice Ryan as to the nature of the case and who the parties were. So the plaintiffs are members of the senior management team employed by the Lishin mine in Tipperary, and they identify the plaintiffs who were the senior management there. Mr. Elms was previously employed in the same role currently occupied at Anglo American, the company that owned the mine, prior to its takeover by the third defendant, Vedanta Resources PLC. And we can see from the next paragraph that the first defendant, which is the Irish subsidiary, operates the mine in Lishin. The second defendant is a business division of the third named defendant and not a separate legal entity. The third named defendant is the parent company of the first defendant. So for all intents and purposes, the second and third defendant are deemed to be the PLC. And we can see the nature of the case, which is essentially an employment case. After a fatality at the mine, the parent company, I don't mean to be pejorative, swooped in to take over. And as we can see under background facts, set out a history of suspicion and ease going back to February 2011 when the defendant companies took over Lishin Mines. The spark that ignited the dispute, giving rise to the application, was the tragedy. Vedanta headquarters in South Africa reacted swiftly to the tragedy. On the very day the accident happened, Mr. Lungowe had been appointed Chief Operating Officer of Vedanta Zinc International. He was, so that's controlled by the parent. He was dispatched to the mine and arrived, immediately began an investigation, accompanied by a mining expert. Present in addition were Vedanta representatives in Black Mountain Mine in South Africa. Mr. Lungowe then carries out an investigation. Mr. Elms, the plaintiff, disposes in an affidavit that Mr. Lungowe told him he'd been appointed to investigate not just the accident, but a previous facility. And a quotation, his investigations would find fault with senior management in both fatalities. Mr. Lungowe expressly advised me he had instructions from Mr. Kumar, that's the Chief Executive Officer of PLC, to find management responsible for failing in respect of both the foregoing matters. There's then evidence at page 6838 of Vedanta PLC taking control of matters. A video link presentation took place in April 2013 to the Executive Committee of Vedanta Worldwide. Mr. Elms in his affidavit said Vedanta is a huge multinational company with branches and subsidiaries, and the executive of those units dialed into the conference and witnessed the events. He'd previously seen a slide referring to the fatal accident and understood it to be presented at the meeting, but the slide that was actually used and presented by Mr. Kumar was different. This one said specific remedial actions. You can see discipline of senior management at Lishin for failure control, alignment of risk profile with the Vedanta value system, and meeting the Irish government to discuss interventions taken by Vedanta at Lishin. So it's evidence of this matter being dealt with at a central level. That's also reflected in another incident recorded in the judgment, if we turn to 6840, giving potentially an insight into how the company is run. Penultimate paragraph, another incident which should be mentioned in the sequence of events is a meeting that took place on the 15th of May between Mr. Kumar and others of the Lisheen management with representatives of Beat Island. There had previously been discussions about the use of land occupied by the mine and its facilities when it was exhausted and no longer in use. The understanding of the Irish management was that the land would be given over for use in beet production and had been discussed with the local organisation. The expectation was the mine would be closing with a small number of years and the land would then be available. However, at the meeting, Mr. Kumar, the CEO of the parent company, made clear to the representatives of Beat Island that it was not going to be the case and the mine was going to continue for years into the future. At the time when this meeting and announcement took place, the two claimants were on sick leave, but another had not yet gone. And Mr. Elm complains about the announcement, saying it was completely humiliating to all of the local management. It was utterly bizarre the announcement was made without ever being discussed with the Irish management, and it severely damaged relations with local interested parties. Now, again, please can I reiterate, this is not a case that's going to play centre stage at any trial, but in a case in which I'm seeking to show that they're all little bits of what no doubt will soon be, with disclosure, a larger mosaic. This is nothing, if nothing else, is another source that is capable of suggesting this is a company that exercises a degree of central control. I do not put it, just to be clear, centre stage. I only show it because this is of a different nature. But you'll see, I hope, from our particulars of claim, that there are a significant number of documents that we do rely on. But I just draw it to the court's attention because of its different quality, or different, rather, source. So where, my lady, my lords, does all this take us? The appellant's case is that the claimant's reliance on this material is all misplaced, and that the court can only conclude that there was no control by the parent over the subsidiary, which at all times, it says, operated as an independent and autonomous organisation, save for the very highest level of cooperation, consistent with its listing obligations and the regulatory framework. These are submissions that are founded entirely upon the witness evidence of Mr. Kumar of Vedanta and Mr. Nadulo of KCM, who give evidence of the corporate separateness and explanations as to how the documents relied upon and the particulars of claim and the evidence of Mr. Day should be to be properly interpreted. Those explanations are disputed, and we submit in large part irreconcilable with the face of some of the documents. Can I just give you a source whereby we set out Mr. Kumar's explanation and cross-refer it to some of the documents? That's dealt with by Mr. Day in the statement to which I have already alluded. He does this between paragraphs 21 and 75 at MS 1473. And it reflects, we say, the very real evidential dispute between the parties. This is not a case we would respectfully submit, of which there may be some, in which a party, in order to try and get through the jurisdictional threshold, makes a bare assertion of control and supports it by some peripheral documentation, or documentation that is patently being taken out of context. It's a complicated dispute about corporate structure and relationships that are not open to public interrogation. And in any event, it would be extremely unsatisfactory, we submit, to seek to resolve it on the basis that my learned friends suggest you do, by simply accepting the evidence of Mr. Nadulo and Mr. Kumar because they must know. Deeply unsatisfactory, would respectfully submit to say that factual disputes can be resolved by a sworn statement of an employee of a party. Again, I apologise for making what are undoubtedly self-evident points. But the position is in fact a fortiori in this case. It's a fortiori because, as the High Court held, KCM and Mr. Nadulu have been found on previous occasions to mislead the English High Court. And KCM as an organisation has been the subject of fierce criticism by judges of the High Court. That was a matter considered by the learned judge below. He deals with it at paragraphs 18 to 20 of his judgment, MS 432, and he reaches a conclusion at paragraph 120, MS 452, that it amounts to a reason not to rely upon that evidence in order to make adverse findings against the claimant. Now, my lady, my lords, that is not an approach that has ever been challenged by the appellant. They didn't object to the points that were being taken as a point of principle before Mr. Justice Coulson. When Mr. Justice Coulson relied upon that, they did not challenge it in their grounds of appeal or argument before the Court of Appeal. You will not find any complaint about it in their printed case before this court, and the only objection taken to it was in the course of my learned friend submissions by simple reference to an authority without taking you to that. We say his lordship was entirely entitled to take that into account as a factor.
Because it's been drummed into us for all the years of our practice that you don't take findings from another case and build on them.
Of course, but
And I suppose after a trial, that principle would be fully effective. But at this stage, are you allowed to throw it in for what it's worth?
you must be, my lord, because otherwise you ignore that which is there as a matter of fact and record. Of course, I cannot rely upon any of those earlier findings as probative of the issues before the case. I may certainly be able to cross-examine Mr. Ndulu as to credibility in relation to that, insofar as that's going to be relevant to any issue at a trial. But for the purposes, particularly when it is being said by the appellants, just rely on Mr. Ndulu and Mr. Kumar. You can safely rely on that to discount the claimant's interpretation of the documentation and their assertion of control. You can discount our witness on that basis. So it would be an extraordinary result if, notwithstanding the very robust criticisms of the High Court over a series of cases, including a specific finding that Mr. Ndulu gave untrue evidence, that that is not a factor that can be taken into account. And I say it's never been challenged. The position we therefore respectfully submit is that the court below was presented with a real dispute on the facts, going to the heart of the issue, with a range of evidence from different sources from the claimants, in circumstances in which it is obvious that there may be very relevant additional documents to come on disclosure, and reached the conclusion that the claim was not bound to fail. And we respectfully submit that was the right conclusion to reach in this case. This is a case that most certainly deserves the right of a trial. My lady, my lords, that's all I was intending to say on evidence, but I would like to answer, if I may, my Lord Briggs's question about disclosure and the availability of disclosure in a service out. It's been considered, so far as we can recall over the lunch break, in two High Court cases. The first under the old rules, which was a case called Remain Punjab. It's not in the bundles. It's reported in 1989, 2 Lloyd's reports, 424. It's Mr. Justice Hurst, as he then was. His lordship held that the court certainly had a power, but it should be to order disclosure, but it should be one exercised only rarely, and he refused to make it in that case. In the post-CPR world, those principles were considered applicable by Mr. Justice Silber in a case called Vava. That's 2012 EWHC 1969. That was about a very limited issue as to whether or not the defendant had its central administration within the then terms of Article 60 of the judgment regulations, had its central administration in London. And his lordship ordered limited disclosure on that issue. again stressing the limited circumstances in which disclosure will be appropriate. Mr. Justice Hurst having explained that it can defeat the very purpose of trying to have a quick process if there is disclosure tagged onto it. In a case such as this, whilst one can well see why the claimants would welcome the opportunity to have disclosure, one can see a number of obstacles. I mean, not least that the issue is not a simple discrete fact as to where a company is domiciled or where it has where its central administration or incorporated. It's about whether there's a real issue between the parties. So it's about the nature and degree of control that the parent had over the subsidiary, which requires disclosure not only in respect of the domicile defendant, but also potentially in respect of the non-domicile defendant. The court's always going to be reluctant to make orders pre-establishing jurisdiction against a foreign defendant. But one can well see that that's the type of issue in which there's going to be a need for pretty substantial disclosure, which may defeat the object. But again, each case will turn on its facts. It may be a way through in some cases to cut to the issue early on, but possibly not in a case such as this. I hope that answers my Lord's question.
Thank you.
Could I deal then next with appropriate forum? We deal with this between paragraphs 165 and 200 of our printed case, including references to the authorities identifying the very narrow grounds for appellate review and the reasons for that. My roadmap identified 7 points. I'm actually going to make 8, having considered a point made yesterday. First point is this. The appellant's attack under this heading is once more premised on the assertion that the claim is simply a device, an improper device. That this is, to which they're entitled to say that under this head. This is one that's legitimate to look at motive if the court thinks that the tail's wagging the dog. But for the reasons that I identified this morning, in light of the factual findings to the contrary by the learned judge, it's not one open to the defendants here. It's very different from cases such as one in the bundle called Pacific International, where a company, the domiciled company, was simply a company that was had no assets, brought back to the register simply for the purposes of establishing jurisdiction in a case about a football team in Kiev. They're obviously very different here. You have the findings of Mr. Justice Coulson. Secondly, the question of appropriate forum is only reached once the court has already made a number of highly relevant conclusions. So it's already decided there's a real issue as against Vedanta, the parent, which, as Lord Gough made plain in Sequensar, is the end of any further consideration of the merits. It has concluded that it's reasonable for the court to try that real issue. That's conceded here. The court has furthermore decided that there's a reasonable case in law and fact against KCM. That is also conceded here. And it has also decided that KCM is a necessary and proper party to the English litigation, a point that is now conceded here, and of real significance to the subsequent question as to whether or not England is the appropriate forum. The concession before this court...
Can I just interrupt
a
moment?
sorry, my lady.
Is it conceded that they're a necessary and proper party, or
Yes.
that they are a proper party?
I'm so sorry.
Because necessary would dictate the answer to the question.
Forgive me
It's
if I...
either necessary or, isn't it? So
It is, my lady. My lady's entirely right. And no doubt Mr. Gibson will correct me immediately if I'm wrong, but it is unclear. So the point was challenged below, but it is not... The basis upon which it accepted is unclear.
Okay.
I hope that gets it right. Now, that's on whatever basis, it was an appropriate concession in the circumstances identified by the learned judge that in almost every respect, the trial of a case against Vedanta will require consideration of virtually the same issues as the trial against the subsidiary. It will be, in effect, a unitary investigation. And the fact that the necessary and proper party test is either satisfied or conceded is a matter that is in no way conclusive, but is highly relevant. And can I just show you some authority for that, which is in the judgment of Lord Justice Mustill, as he then was in Eras Eli. You'll find that at volume 7, tab 81, and the relevant passage, it's in the Lloyd's reports, is at 5168. I should say that in Seekensar, Lord Justice Mustill's conclusion in this case that the merits test is relevant to the question of appropriate forum was overturned by the House of Lords in Seekensar, but there's never been any doubt about the passage that I'm taking you to now, which has been subsequently cited. You'll see it in other authority. And it's under the heading The Discretion and Order 11. The appellants take exception to the following passage from the...
Sorry, I think I'm on a wrong page. I'm on 5168.
Yes, does my lord have first column? Was my lord in the Lloyd reports?
Oh, I've got it, yes. Yeah, thank you.
It's say from the judge's discussion, it's further unclear that the plaintiff it's further clear, I beg your pardon, that the plaintiff must satisfy both the test of necessity or proper party, and that the case is a proper one for service out. That this is so, I was reminded forcefully by counsel, by reference to authority. That brings into play the discretion, the application of principles enunciated by Lord Gough in the Spiliada. But having said that, I would think that necessary or proper party cases will often be just those type of cases when leave will normally be given. Once a judge is satisfied on the high test that a person is a proper party, since the forum is already chosen, it will normally be a case when the discretion is exercised in favour of service. But the question must be posed in two distinct stages, I accept. Is the defendant a necessary or proper party? Is it right to bring him here as a party? And then Lord Justice Mustill said this: the appellants treat this as a principle to the effect that there is a presumption in favour of granting leave in a case falling within paragraph C, and they complain that it's an unjustified fetter on the free exercise of the judge's discretion. If this had indeed been what the judge meant, we would have thought the criticism well-founded, but we do not so read the passage quoted. The judge was saying only that in practice the factors which make the party serve the necessary proper party within paragraph C will also weigh heavily in favour of granting leave to make the foreigner a party, although they will not be conclusive. So understood, the judge's statement is obviously right. The third point is that the appellant's arguments are irreconcilable with a finding of fact reached by the judge on the evidence that the proceedings against the domicile defendant will be proceeding in London in any event. The judge rejected the defendant's submissions to the contrary, which weren't based on any evidence but simply assertion. For your note, he reaches that conclusion between paragraphs 164 to 6 of his judgment at MS 460. It's plainly a judgment on the evidence he was entitled to reach. That takes me to my fourth point, which is the fact that there will be a trial proceeding in London in any event against the parent is an additional highly relevant factor in the consideration of the appropriate forum to try the claim against KCM, not least where, as stated, this is in effect going to be a unitary investigation. But that is a point that is made repeatedly in cases concerning a service out. It's exemplified by at least all the cases relied on by the learned judge, but can I just show you one of them, because it's referred to now in so many cases that follow, which is the judgment of Mr. Justice Leggett, as he then was, in OJSC case. You'll find that in Authorities Volume 1 at tab 13, MS 3319. Because of time, I wonder if I can just summarise the position and just then identify the paragraphs. But it's a short judgment that encapsulates and deals with a number of points raised by my learned friends, and it is one that we would respectfully submit merits a full reading. This was a case in which, as the court will see from paragraph 5, the judge accepted had very little to do with the United Kingdom and everything almost to do with Russia.
Forgive me, I must have missed a digit from your page reference.
My lady, I'm now looking at paragraph 5, it's 3321.
3321. Thank you.
So paragraph 5, on a quick read, one can see that this was a case that was all about Russia. And the only basis for jurisdiction was the presence of a domiciled party here. His lordship held between paragraphs 6 and 7 that you can't go behind, he couldn't in that case go behind the claimant's evidence that they had a desire to sue the domiciled defendant, and therefore he couldn't conclude it was a hook. Between paragraphs 8 and 10, he dismisses a submission that the fact that the claimants could have chosen to sue in Russia was decisive. Between paragraphs 11 and 15, he rejects the submission that because one defendant might be called the main protagonist, that's a factor, and a minor one might be in London, that's a factor that should go into consideration. You'll see how his lordship deals with it. And his lordship's analysis is all of a piece with the great significance of the fact that a trial is taking place in London, bearing upon the question of appropriate forum. And that's an authority that's been cited in all others, not least here at first instance and in the Court of Appeal. And the approach reflects the concern of courts that has long obviously predated Owusu, not simply to avoid the costs of duplicating trials, but the risk of irreconcilable judgments. That's a principle that underlines common rules with other countries, not least lis pendens. Indeed, lis pendens is a rule that has been expanded under the recast regulations to include a power for the court to stay proceedings in light of other proceedings outside the EU. That's a new development of lis pendens in our scheme. Having two courts look at the same subject matter is, as Lord Diplock described in the Aberdeen Deva, a recipe for confusion and injustice. For your note, volume 9, tab 93, MS 5589 by letter D. There is no reason at all, we would submit, to think that Lord Diplock's concern and the courts that have regularly been expressed by courts was in any way confined to commercial cases. Fifthly, the judge's approach was, we say with respect, unimpeachable. Could I just show you how he approached it? We can pick it up at paragraph 148 of his judgment at MS 457. He starts at paragraph 148 by identifying the correct legal test. That set out the classic test in Liada and its description by Lord Collins in Ultimo. He identifies at 149 that there can be two issues that arise out of that. The bare question of appropriate forum, and if that is not satisfied, then going on to look at the risk of injustice. And his lordship starts his analysis with the identification of the natural forum. And over paragraphs 151 to 156, he identifies all the factors that militate in favour of his conclusion that Zambia is the natural forum. And at 156 asks the question, is there a difference? I beg your pardon, can the appropriate forum be somewhere else because of the fact of the trial in London? We respectfully say that my learned friend's submissions that the judge did not carry out a balancing exercise do not withstand the plain reading of the judgment. His Lordship then from paragraph 157 and 158 sets out what he identifies as the correct approach. And then he carries out a analysis of the significance. He identifies the counter-arguments raised by the defendant before him. He addresses those head-on, he provides his rationale for that, and he reaches his conclusion.
How appropriate is it for you to secure victory on this issue by, in the light of Vedanta's submission to the Zambian jurisdiction, saying to us and to the lower courts, no, actually, the case against Vedanta will proceed here? Are you not securing your own victory by your own election?
Well, no, my lord. I mean, factually, we started this case against Vedanta before there had been any submission to the jurisdiction. So that's a submission to the jurisdiction that arose afterwards. Now, I would like to clarify a point contained in our printed case, which is whether or not the judge is entitled to look at the factors that arise after the ex parte application, which we've said the judge isn't entitled to, relying not least upon Red October and the analysis in Red October. But can I point out, I think I must, to the court, that my reading of Lord Hope in Lungowe is certainly to suggest to the contrary, that it may certainly be arguable, and that would indeed accord with some degree with common sense as to why it's possible on an inter partes hearing. So I don't pursue that. I don't pursue a technical point, but I pursue a factual point, which is when this case started, the claimants sued in the jurisdiction they had to sue in order to sue Vedanta. So that's an entirely legitimate, indeed it is the only starting point for the case.
Would they not have started in Zambia against KCM and sought to serve Vedanta out of the KCM jurisdiction under what I assume under the Zambian civil procedure rules are very similar provisions?
But my lord, I couldn't tell you what the provisions are in respect of Service Act. What I can tell you is that the claimants elected to sue Vedanta in the country in which they are mandated, and they are perfectly entitled to do so. Indeed, as you'll see, Mr. Justice Leggett, in the case in which I referred you to, rejected that somehow it's for the court then to manage in light of any concessions on jurisdiction in other jurisdictions. But the
fact that they're entitled to do so, and I don't think at this stage of the argument anyone is challenging your entitlement to start and go on against Vedanta in this jurisdiction. Does that really address the proposition that nonetheless, in the light of Vedanta's readiness to submit to the Zambian jurisdiction, the real risk why there is a serious risk of irreconcilable judgments and duplicative proceedings is because of a decision between two, let's assume, jurisdictions where you can get access to justice? Your side is choosing the English one rather than the Zambian one.
Yes. And it shouldn't be for the court examining where is the appropriate forum. We would respectfully submit to necessarily second-guess that. It deals with the case before it.
That's what these disputes are about.
Well,
I don't question your right to sue here.
Yes.
There's a disconnect, isn't there, between that right, which is not at this stage of the argument being challenged,
yes,
and the analysis of the question how much weight to give to a risk of irreconcilable judgments, if that's a risk which is, if you like, caused by or would be avoidable by a choice of the natural forum, always assuming you can get access to justice.
Yes. Well, my lord, it's not necessary for my case to succeed in order to demonstrate that the court could never take that into account. But on the facts of this case, as found by the judge below, including the reality of what trying to proceed in Zambia would be like, which is the next test we're going to look at, looking at the evidence in the round, the judge reached a conclusion, which we say is entirely justified, that it was the appropriate forum. And this court...
Did he analyse that question? The question of what was the real cause of the risk of irreconcilable judgments? And plainly he regarded that as a trump factor.
Yes.
Having previously found that Zambia was obviously the natural forum.
Yes.
But did he analyse the question, well, what weight should be given to it, bearing in mind what causes the risk?
No, my Lord, there's no detailed analysis of that, but that in no way vitiates, we would respectfully submit, the balanced conclusion that he reached, having gone through all the other threshold tests, looking at the evidence of the whole, looking at the arguments presented by the defendants, and reaching the evaluative conclusion that he did. And in circumstances in which the authorities are so clear about the need for caution before intervening with those first instance evaluative decisions, that was certainly a decision that he was entitled to reach. And it will be a fortiori, I will respectfully submit, the soundness of that conclusion when I make some submissions to this court on the issue of access to justice in Zambia.
I think you have a statement of principle that appears to be broadly favourable to you in paragraphs 8 and 10 of the UKSC case.
My Lord, I do.
Where Mr. Justice Leggett notes that the anchor defendants in that case were prepared to submit to the Russian jurisdiction. Then at paragraph 10 says, well, it doesn't cut the mustard. I mean, putting it colloquially.
Yes, my Lord, I rely on that. I also rely more generally on the passage I've taken you to from Lord Gough in Connolly. I mean, the claimants would like to have justice against PLC, and this is an absolutely appropriate forum for them to come and seek justice against PLC. The fact that Vedanta says, oh, well, you can sue us, we'll submit, isn't something that can just be... The fact that Vedanta do it is not a factor that can materially displace the conclusions reached by the learned judge below, I mean, even if it's a factor that can be taken into account. Because otherwise it becomes I mean, if nothing else, it becomes a tool for defendants to pick their favourite jurisdictions. And this is in circumstances in which the judge found that the defendants were broadly equivalent defendants, couple defendants. So this is not a case in which one can categorise major or minor protagonists. This is very much a case in which, on the claimant's case, in which the claimants, seek accountability against the parent. And this is the appropriate jurisdiction for that case. And that's the appropriate prism to look through it, we say, with great respect. And we say this really can't be a basis to interfere with the judgment below. Sixth point, my lords, my lady, is that there is nothing in the authorities or the judges of application of those authorities that amounts to an unseemly rush to bring a foreign party into the jurisdiction. As I said before, this is a case that has to satisfy a significant number of tests, many of which are now conceded. And in any event, we should caution ourselves against the use of extravagant adjectives to describe the assumption of jurisdiction. As Lord Sumption observed in Abella, paragraphs 53 to 54, Authorities 2, tab 30, MS 3605, in the modern world, it's no longer accurate or appropriate to describe service as the exercise as exorbitant jurisdiction. Indeed, that was, in fact, the very point made by Lord Gough 30 years earlier in Spiliada. Fact of life in the modern world, subject to all the tests to make sure it's not being applied inappropriately. My seventh and final argument under this head is in response to the arguments advanced by Mr. Gibson yesterday under this heading, which essentially amounted to public policy reasons as to why it's so preferable to bring the case in Zambia to support the Zambian emerging environmental bar, for the other reasons advanced by Mr. Gibson, which are matters of public policy. But as the House of Lords explained in Lungowe, matters of public policy are not relevant to the consideration of appropriate forum. Could I just take you, please, firstly to the speech of Lord Hope. So that's Authorities, Volume 1, Tab 10. It's in the passage that we can pick up at MS 3240. under the heading public interest, in my opinion, the principles on which the doctrine of forum rests leave no room for considerations of public interest or public policy which cannot be related to the private interests of any of the parties or the ends of justice in the case which is before the court. His Lordship then continued, identified authority by H said, the proper approach therefore is to start from the proposition that a claimant who is able to establish jurisdiction against the defendant as of right in this country is entitled to call upon the courts of this country to exercise that jurisdiction. So if the plea of forum cannot be sustained on the grounds that the case may be tried more suitably in the other forum, however desirable it may be on grounds of public policy, or public interest or public policy, that litigation should be conducted elsewhere and not the English courts. On the other hand, if the interest of all the parties in the end of justice require that the action in this country should be stayed, a stay ought to be granted, however desirable it may be, on grounds of public interest or public policy, that the action should be tried here. So his Lordship declined to follow the United States, which interestingly includes the Union Carbide Bhopal case, in which the American courts declined jurisdiction and the impact is a matter of ongoing impact is a matter of public record. And his Lordship respectfully agreed with Justice Dean that the court is not equipped to conduct the kind of inquiry and assessment of the international as well as the domestic implications that would be needed to follow that approach. However tempting it may be to give effect to the concerns about the expense and inconvenience to the administration of justice of litigating actions such as these in this country on the one hand or in South Africa on the other, the argument must be resolved upon examination of their effect on the interests of the parties who are before the court and securing the ends of justice in their case. I would hold that considerations of policy which cannot be dealt in this way should be left out of account. And see to like effect, could I just flag it in light of time, Lord Bingham at MS 3235 under the heading public interest.
That analysis seems to be mainly about a case where a claimant establishes jurisdiction as of right, so that public interest can't interfere under the old pre-Owusu jurisdiction to stay in those circumstances.
Yes.
Rather than a case where you're seeking to establish jurisdiction by service out.
Well, my Lord, with respectfully submit, it's difficult to see why public policy then gets reintroduced. But my Lord, the distinction is one of, this is of course right, but it is not one that we respectfully submit that gives rise to the opening of the door for public policy concerns. Can I finally say this, as for reasons given in our printed case, there's no reason to consider that the trial of issues against KCM, in addition to those, I beg your pardon, the trial of the issues, will give rise to any particular practical difficulties. Of course, Zambian law will apply, but it closely hews to English law. The national language is English. It can be expected that the key documents will be in English. There's a successful history of trying Zambian cases before the English courts. That includes a case, interestingly, brought by the Zambian Attorney General before this court, which concerned allegations of corruption against high officials of the Zambian state, including the former president of Zambia. That's in the bundle. There's no need to pull it up. It's got a case called the Attorney General of Zambia against Mir Care Tsai and others. Authority 3, tab 33, MS 3771. In that case, the High Court judge went to Zambia to sit as a special examiner. And indeed, the Queen's Bench Division has very recently handed down a judgment in a case concerning the activities of a subsidiary in Sierra Leone, where the judge also sat as a special examiner taking evidence from Sierra Leone nationals for 2 weeks in Freetown. So there's nothing unusual per se in that, if that's what's required in a case. Furthermore, KCM itself, in unrelated litigation, sought to persuade the English court that it was the appropriate forum to hear a Part 20 claim, notwithstanding the existence of an exclusive jurisdiction clause in favour of Zambia. Can I just show you how KCM put it to the courts? You find that in the authority of the Konkola copper mines against Koromin. It's in Authorities 5, tab 62. And if one can just look at paragraphs 20 and 21 at MS 4622. So this is a case that arose out of an incident at the mine. On behalf of KCM, counsel relied at para 20 heavily on the approach of the Court of Appeal, exemplified in the Alamira and Donoghue and Armico, about the risk of inconsistent decisions due to fragmentation of proceedings is where possible avoided, even if that involves that an exclusive jurisdiction clause is not enforced. And at paragraph 21, KCM further submits that arguments advanced in favour of a setting side service, this is against, are comparatively little weight. This is KCM submissions. There's little or no material difference between Zambian law and English law, and issues of Zambian law have to be determined in the English proceedings in any event in relation to the claim against Coromine. Even if the claim against the Zambian insurers takes place in Zambia, many of the witnesses of fact will have to travel to England to give evidence here because of the need to determine the same factual issues. Even if the experts have to visit the mine, it's more convenient and cost-effective that they only have to give evidence at one trial. The number of Zambian witnesses who would have to give evidence in England on the structure would like to be few. The cost of a Zambian trial might be well less of an English trial, but there were two trials. KCM would have to bear the lots of two costs. Could I move to the alternative ground of access to justice? And can I divide my submission firstly by some observations on the intervention by the government of Zambia, and then look at the appellant's case? Just four short observations in respect of the Attorney General's submissions. Firstly, is just to point out that the government of Zambia, in effect, intervened at first instance when, on behalf of the appellant, a witness statement was served from the then serving Solicitor General on behalf of the Zambian state, supporting the appellant's contention that the case could be fairly tried in Zambia. Just for your note, the Solicitor General's witness statement is at Core Bundle 4, tab 43, see in particular paragraphs 6 and 8 at MS 1364. So the evidence has already been factored into the judge's consideration. We don't detect any new evidence in the Attorney General's submissions, but insofar as there is, as opposed to legal submission, it wouldn't be appropriate in any event to introduce it at an appellate stage. Secondly, is to point out that there are two versions of the Attorney General's submissions. There's one that's contained in the core bundles, but that's the version that was put in for the purposes of permission. There's a second version, which is the post-permission skeleton argument, I beg your pardon, written submissions. And there are material deletion because it's no longer contended that the acceptance of jurisdiction by the English court amounts to a form of neo-colonialism. So whereas that's contained in the original, can I have the reference to one? Where that's contained in the...
Well, we tried to get to the bottom of this yesterday, and we must work from the right document.
Yes.
Insofar as I'm looking at Supplementary Volume 4, tab 25, page 825, am I looking at the right document?
No, my lord, you should have it's MS 1364. That's where you should have it.
And where's
Core,
that?
there should be a replacement in Core Volume 4, tab 43. Can we sort that? Can we sort that out and make sure that the court has the right version? I don't need to look at it for the purposes of the submissions that I'm making.
1364.
No, it can't be 1364.
Are we talking about the supplementary or the main bundle? Because the 1364 is page 2 of the Solicitor General's evidence, which I assume is the one you've just been referring to.
I'm so sorry. That's entirely my mistake. I've given you the reference in my notes back to the Solicitor General. My lady, my lords, might we do it this way? The parties will liaise. We will make sure you have a clear steer as to where the appropriate document is to be found.
Yes.
And if it's not in your bundles, we'll ensure that it is provided.
Well, coming in this morning, I found it, and no doubt my colleagues have too, found a document loose on our desks. Would that be the final version?
Well, I can only guess, but I would anticipate...
I think we can await your clarification, but I would like that clarification.
My lord, I don't need to, for the purposes of the very short points I'm going to make, about the...
I know, but we must work from the right document.
My Lord, I entirely agree, but
Very well.
we didn't hand in the loose leaf, so I can't speak to its provenance.
I see.
We will undoubtedly make sure, in liaison with my learned friend's team, that the correct version is contained. But
My Lord, it is the one that you identified in file supplementary bundle for...
Is it? It's the same. It's the same.
Time tone is the right one.
Which page is it?
MS 825.
825.
Which bundle?
Supplementary.
Supplementary 825.
Divider 25, which I think is where my Lord was.
I was there, but we've been told that's not the final version.
Oh, I see. I'm so sorry then, my Lord. Then I've caused completely unnecessary confusion, and I apologise.
Very well.
Well, the heading is extremely confusing because it's headed, the document at 825 is headed Intervenors Submissions in Support of an Application for Permission to Appeal, which doesn't sound like intervenors' final submissions on the appeal. There we go.
But you think this is an edited version of
the
earlier document? Because the earlier document combined an application to appeal with the intended intervention.
It's the earlier document, my Lord. You went back to the earlier document. This is the evidence.
Well, in any event, it's no longer said by and rightly so we say, it's no longer said by the Attorney General that the acceptance of jurisdiction by this court is a form of neo-colonialism. What is still maintained is that it would amount to the undermining of the sovereignty of the Zambian nation. And we say that's a submission that is, we say with great respect, misplaced for two interconnected reasons. Firstly, the issue has nothing to do with sovereignty. Judgment has no legal effect, obviously, in respect of the Zambian state at any level, international or domestic. Nor is the court required, nor did it, have to conduct any form of inquiry generally about access to justice in Zambia. The question was a very narrow one under domestic law, whether in this particular case, with this particular features, there was a real risk of the claimants not receiving justice. But in any event, there is no principle that precludes an English court from criticising a foreign government when necessary to do so to give effect to one of our own domestic laws. In the context of applications to serve out, courts are often required to ask whether the risk of injustice, whether there's a risk of injustice if the case proceeds in a foreign court. And the allegations in those cases, often now in commercial cases in respect of the former Soviet Union, the allegations there are not of simply lack of funding. They're of wide-scale judicial corruption or state interference with the courts of far different nature here. And as Lord Collins identified in Ultimo, the response, of course, those issues may give rise to notions of comity. But as Lord Collins explains in Ultimo, that is incorporated by the English courts by the nature of the test that is applied. Can I just show you how His Lordship dealt with it in Ultimo, which is in Volume 1, Tab 6. And if we'd start at paragraph 95, page 3100. This is, I'm just going to take, in light of time, if I can take it relatively briefly. His Lordship at 95 says that depending on the circumstances as a whole, the better view, the burden can be satisfied by showing there's a real risk that justice will not be obtained in the foreign court by reason of incompetence or lack of independence or corruption. Of course, if it can be shown that justice will not be obtained, that will weigh more heavily in the exercise of the discretion. And then it looked at, is the court able to find justice not be, or may not be done because of endemic corruption in the foreign system. And then there's reference to Buttes, which I am not going to take the court to. But paragraph 97, His Lordship says, comity requires that the court will be extremely cautious before deciding that there is a risk of justice will not be done in the foreign country by the foreign court. And that is why cogent evidence is required. But contrary to the appellant's submission, even in what they describe as endemic corruption cases, there is no principle that the court may not rule. So the court deals with issues of comity by the requirement that the risk of injustice is demonstrated by cogent evidence. That's a test that the learned judge at first instance expressly reminded himself of at paragraphs 171 and 174 of his judgment, MS 461. The third point, in response to the Attorney General's submissions, is that courts, a fortiori an appellate court, should adopt some care when receiving evidence from a foreign state that goes beyond the mere descriptive and extends to a plea that jurisdiction should be refused, particularly, I may say, with no disrespect to the Attorney General, where as a matter of fact, the Zambian state has a 20% interest in one of the parties before the court. But the concern might be thought to be reinforced by the fact that were statements of sovereignty, if I can use that as shorthand, to become accorded significance in service out proceedings, then not only might they become commonplace, but they may arise, and I need to put it no higher than this, I just flag the issue, they may arise in respect of countries in which one party might enjoy particular influence with the government of the day for reasons that may be entirely benign, but they may be malign, which could lead to the paradoxical result that statements of sovereignty would be proffered more frequently by countries in which the respect for the rule of law was at its weakest. Now, it's no part of my case, let me be plain, to suggest that this explains the provenance of this particular intervention. But if there was needed to be insight as a matter of generality as to how large corporations can be perceived as exercising enormous power over governments, and therefore the need for caution before accepting that evidence generally, or for getting into a debate into court as to whether or not it should or should not, see the judgment of the High Court in the Naizulu case. Can I just take you to some passages? This, as with the other passage that I took you to earlier, were not subject of any criticism by the Zambian Supreme Court when it reviewed the case. So we're in Appendix Part 2, Volume 9, tab 104, at page 2916. And the first full paragraph, his lordship said, in my view, the Act is self-sufficient to deal with the present situation. The plaintiffs approved their case against the first defendant, that it was reckless and had no regard for human, animal and plant life. The only hypothesis for a powerful multinational to supposedly act with impunity and immunity is that they thought they were politically correct and connected. These courts have a duty to protect poor communities. I agree with the plaintiff's pleading that the first defendant was shielded from criminal prosecution by political connections and financial influence, which put them beyond the pale of the criminal law. And then this very pleading explains the difficulty that the regulatory agency, not insulated from political control, operated under difficult circumstances. They did the best thing they could, shutting out KCM operations. They were dealing with a truant investor. Now, that's the High Court of Zambia. It's not a campaigning NGO. That's not a paragraph that was criticised in any shape or form. And if I may return to my Lord Briggs's question, to go back to appropriate forum and to what degree can it be taken into account that Zambia is available, it may be thought that if one is advising the claimants who want to proceed against the domiciled defendant as to whether they should pursue it here or they should take up Vedanta's offer to proceed in Zambia. And with this as a matter of public record, it may be thought that very serious consideration would need to be given before accepting that invitation. And that certainly can be taken into account if the court considers that it can take Vedanta's invitation into account under appropriate forum.
If you're moving from Naizulu, Mr. Justice Coulson notes that so many of the claimants fail to get damages. He throws up his hands in horror and says that's disastrous. And he throws that into the equation in favour of a conclusion about no substantial justice. Well, you've read the Court of Appeal's judgment, as we now have. I'm terribly sorry, but if claimants don't prove damage, they won't get damages. We must be awfully careful Oughtn't we to be? About criticising, for example, that?
Yes, my lord, absolutely. And that's, if I may say so, a perfect segue into my next section, because I'm going to seek to identify the context in which his lordship analysed Naisulu, to show that one must be very careful before taking on the face of the fact that they were able to get to court, in light of the evidence that was before the learned judge, which I'm going to show the court, one must be very careful in drawing that conclusion. I hope I can be able to do that by moving to the
Thank you.
Next part and final part of our case, which is the question of injustice, which I'm going to do in a slightly different order to the roadmap. It's in our printed case.
And just before you do, I know you're under pressure of time, and one way of looking at that passage in the judgment in Naisulu is actually, rather than giving reason for any doubt about the independence of the Zambian courts in private litigation, he's drawing a distinction between his ability to conduct an entirely independent trial and the problems that arise in a criminal case where the state is the prosecution and in a regulatory case where the regulator is owned by the government.
Of course, the court well knows that my case is not based on access to justice for any moment on any degree of lack of judicial independence in Zambia. It's based purely upon the realities of funding. Could I just remind you of the paragraphs in our printed case, which are 201 to 245 at MS 352. But can I show you three summary documents that go with it? The first is Annex 3 to our printed case, which is at MS 380. Annex 3, first page at 380, is just a short description of who the various deponents of the witness statement served on behalf of the claimants were. There were also a few witness statements from the claimants themselves not listed on here, but it gives you a description. And then what we do at 381 and following is we identify the particular issues as to funding that were live before the court, and we cross-refer to the evidence. And if those references, the references I'm afraid are out because of the problem in the bundling, the court I think has been emailed an updated version. But it shows that for every point raised by the appellant, there was an answer based on evidence before the learned judge. We also prepared a table dealing with the Zambian cases relied upon by the appellants. You'll find that, I'm afraid again with inaccurate referencing, at Appendix 2, Volume 8, Tab 90, MS 2299. Could I hand up just a paper version, because I'm going to make some submissions on it in a moment. This is the version with the correct referencing. Can I have a version? Thank you very much. I'm going to give you my version. Thank you. 269.
Thank you.
Can I make before
is this the Access to Justice roadmap?
It's the Access to Justice roadmap.
We got sent over.
No, this is, no, I'm so sorry. What's being handed up is not, handed up is a table that deals with the cases relied upon by my learned friend in support of his submissions. There is an Access to Justice roadmap that was also handed up. Perhaps that can also come up.
And it was emailed, I think, to us yesterday.
That's right, Mark.
Yeah. Thank you. And this one is the same as the emailed one, is it?
The point that we hope comes through from those tables is that there was a great deal of evidence before the learned judge. Every single point made by Mr. Gibson yesterday was made with equal passion before the learned judge and indeed the Court of Appeal. And indeed, there were greater submissions by Mr. at least quantitatively, before Mr. Gibson at first instance, because this was an issue that occupied more time, really, than any other at the trial before the judge. So there's a great deal of evidence on the points. And it's impossible for me to deal with all the challenges in the printed case. So what I'm intending to do is just to deal primarily with Mr. Gibson's submissions that the learned judge failed to appreciate the relevance of the case. And I'm going to need to do that by giving it the context. But can I start off by making this point? The judge, there can be no dispute that the judge identified and applied the correct legal test. He did so at paragraphs 171 to 73 at MS 461. He sets out the principles derived from Altamo and Lungowe. He noted that he was required to find positive and cogent evidence of a real risk. Indeed, as a matter of fact, the judge went further, not just that there is a real risk. The judge concluded that the claimant almost certainly will not find justice. So the appellants need to show that it was not simply wrong to reach that conclusion, that was irrational, but it was irrational not to reach the conclusion even that there was a real risk. What the learned judge most certainly did not do, and we say that a submission to the contrary is not sustainable on the face of the judgment, is carry out what Mr. Gibson calls a Rolls-Royce comparative analysis. He did not ask himself, are the claimants going to get better form of justice in London because of the advantages our system may or may not have? He examined the evidence purely from the correct perspective, which is whether on the facts of this particular case, there would be a real risk of injustice in Zambia. The English courts has previously had to consider whether particularly complex litigation could be fairly determined in the civil justice systems in the region. Connolly, you've been referred to, was a singleton case, but a complicated case. Lungowe, as we know, concerned South Africa. The learned judge considered that Lungowe was a real comparator. He did so at paragraphs, I beg your pardon, and it's worth picking up Lungowe just to make that point. It's in volume 1, tab 10, and if we can turn to page 3231, can I just identify, because of time, the similarities that jump off the page? Just by letter E, his lordship identified some principles that drew him to the conclusions that he did about access to justice. The first is that the claim can only proceed cost-effectively and expeditiously on a group basis. Secondly, that the plaintiff's case raises a serious legal issue, and he identifies what the seriousness of those issues are, the complexity, what they will require to determine, including that detailed expert evidence would be required. Point 4 over the page at 3232, no realistic possibility of legal aid, just as here. Point 5 is there was conflicting evidence about whether or not there would be lawyers willing to act under a CFA in South Africa, but his lordship said that the evidence on balance, well, no, the evidence suggested that it was unrealistic that they would, but there was evidence to the contrary. And 6 was the conclusion that the claimants themselves would have no real means of obtaining the professional representation and expert evidence that would be required. So there were some very real similarities with the case that Lord Bingham, the House of Lords, was dealing with, that led the House of Lords to the conclusion that there was a real risk of substantial injustice in South Africa. Of course, as the learned judge in this case identified, there are some contrasts that are in favour of the claimants here. South Africa was a far more developed legal system. Just look at the composition of the appellate committee in Lungowe, two former members of the South African bar. It's also the richest economy, was then and still is the richest economy in the continent. So the judge applied the legal test. It was perfectly appropriate for him to use Lungowe as a comparator. He didn't completely bind himself to it, but it was a useful comparator. And he applied to that framework his review of a very considerable amount of evidence, which he analyses in great detail, taking all the defendant's points between paragraphs 177 and 198, identifying seven factors, each of which he reasons, each of which he identifies the counter-arguments and reaches the conclusions. Now, the main attack made yesterday by my learned friend was that there was a failure to properly identify the Zambian courts. Had the learned judge done so, he would have appreciated not only that the cases do run, but they can be funded, not least with the help of non-governmental organisations, and a proper understanding of those cases would have shown that there were lawyers well qualified to run the cases. My Lord, it's important to see those observations in their proper context. It's no part of the appellant's case that Zambia cannot cater for cases concerning damage to the environment generally, nor that it doesn't have the means to cater for certain types of group claims. Our case is focused. It is that there is a real risk that an environmental case of this size and complexity, requiring, as it will, the expenditure of considerable costs, cannot be fairly litigated in Zambia, or there is a real risk that it cannot. And it's helpful to ground Mr. Gibson's impeachment of the failure to, he says, to analyse the Naisulu case and others through some of the realities, not least those realities found by the learned judge. So we would say the following are factors that are relevant to take into account for reasons I'm going to explain. This is a claim for a large number of individuals, which obviously makes the litigation more expensive to manage than a singleton claim or a small group. The reasons for that were set out in evidence, not least giving a particular Zambian perspective, because the court had evidence from several sources of experienced practitioners explaining that because Zambian firms were rarely more than 3 or 4 individuals, there is no way, in their opinion, a group of this size could be handled by one firm, but would have to be split between firms, and they gave evidence of the real problems that would cause. So that's evidence. It's also, as the judge held, likely to be a factually complicated piece of litigation. It doesn't concern a singleton spill, but rather multiple spills over many years. Identifying those spills, not least the dates and the volumes, will be complex. One can anticipate the defendant will argue that material damage was caused by other contributions along the waterway, an issue that is likely to be resolved by expert evidence and potentially also by detailed disclosure. This is also a case in which the range of damages are wide, not only personal injury, but damage to land requiring proof of ownership, a matter that in customary lands may be complicated. We also seek injunctive relief. All of this, again, particularly injunctive relief and remedies, will be a matter requiring detailed expert evidence. That is why the appellant solicitor, Mr. Ogilvie, was entirely correct when he stated in his witness statement that this will be complicated litigation. Can I give you the reference? Mr. Gibson also gave it to you, but we rely on it. Paragraph 19C and D of Mr. Ogilvie's witness statement, volume 3, tab 27, MS 794-5.
I know you're running out of time. I won't take up very much of your time at all. Sapizo Stengu, you'll remember that case, it's on your list. 96 plaintiffs. We've got the statement of claim. How's it been funded? Anything wrong with the statement of claim?
Would my Lord forgive me my impertinence because I am going to deal with those cases in order. I'm so sorry, but I do stress the importance of seeing it in the context. The court was given real-life examples from experienced Zambian practitioners and members of civil society whose work is dedicated to the environment. Real-worked examples as to why lack of funding creates a real obstacle to bringing cases before the Zambian courts. They list their own personal example of cases in which there have been compelling grounds to bring a case, but they have been unable to because of a lack of funding. And they explain in detail the basis of why they cannot get funding for those cases. Some of that is dealt with in Mr. Day's statement, paragraph 167 to 70 at MS 1526, but you'll also see it from our breakdown. All of them, or I beg your pardon, many of them addressed Naisulu, which is perhaps the best example, the most prominent example in my learned friend's case. Now, it is right that, of course, Naisulu got to the High Court and received a judgment in its favour. But what is instructive is not the mere fact that it failed for the reasons that it did in the Supreme Court, but why. And there was evidence before the learned judge that gave an insight into some of the realities. And can I just show you the evidence that from the lawyer who had conduct of the appeal before the Supreme Court, Mr. Shepherdande, and his witness statement is in Core Volume 6, tab 57. I'm going to start at paragraph 13, if I may, at MS 1680.
Did you say 13?
It's paragraph. Can I ask the court just to read paragraphs 13, 15 and 16? See also Core Volume 6, tab 58, the statement of one of the 12 whose cases we now learn whose cases we see survived, so you can get again a sense of reality on the ground in the form of the evidence before the judge. That is Volume 6, tab 58, at MS 1690, paragraphs 24 to 26.
Paragraphs?
24 to 26, my lord. 1690. So there is, of course, I recognise a superficial attractiveness to my learned friend's submission, which is, here, look at Naisulu. Here's a case that went on. It just so happens that the judge made a mistake and these things happen. But that is not the explanation on evidence advanced by the appellants. The explanation on evidence is they were required to get those medical reports, but the reality of funding is they never would have got it. See the appellate lawyer's statement. That's evidence, which the judge is entitled to take into account. One of the 12 has no idea he was successful. Can I deal with the other cases by reference to the table, if I may, of cases? So the next case is the Citizens for a Better Environment case. But that doesn't help us because that's a case for 16 farmers. So it's no part of my case to say that no environmental claims can proceed before the Zambian courts. It's a case of this nature, which the judge was right to identify as the correct test. Sinkala, which was a case against KCM brought upon 71, then there is a real dispute, both as to those who did receive money, whether they received the whole amount, and others who said they received nothing. So it's not a case that the judge identified that one could say it's a case that evidences that these cases can be successful. This was a settlement that appears possibly on our case to have gone wrong. It's not a case of it proceeding through to trial at all. Puma Energy is a case I'm going to turn to in a moment when I look at the lawyer's evidence upon which my learned friend relies.
You have only 5 minutes, Mr. Hammond.
I'm going to be super quick, my lady. Shamilo, the last case, is a case upon which we rely. Because, as explained by the witness evidence, it was a case in which there was a finding that workers were exposed to radiation, but they could not succeed because they did not have expert evidence to prove it. And as their lawyer explains, the reason for that is he could not afford it. It could not be funded. The Puma case, which you looked at before, is a case that is progressing, albeit at a very early stage, by the lawyer whose witness evidence was served. That's Mr. Musakawaka, and his evidence is at tab 42 of Core Bundle 4 MS 1340. I don't take you to it in light of time, but you will see that he is a very junior lawyer, with no disrespect for a moment to him, with no experience of dealing with these sorts of cases. He's had a couple of cases that have settled at an early stage. He has the Puma case that is trundling along with 200 claimants. I don't mean that disparagingly. There was a wealth of evidence from the claimants that it is simply unrealistic to expect Zambian lawyers to deal with a case like this. No chance of funding. NGOs, there's evidence from NGOs, they couldn't begin to conceive of funding a case such as this, all of which the judge took into account. He had a mosaic of evidence into which, of course, the cases fell, but they needed to be interpreted within the totality of that mosaic. He did that. We respectfully submit, entitled to do that. He was not irrational or perverse. He didn't fail to take anything into account. And we respectfully submit this court, as the court below, the Court of Appeal, should not interfere. My lady, those are my submissions on behalf of the respondent.
Well, Mr. Hermer, you made it within the, the time. Thank you very much indeed. Ms. Kinsler? Mr. Gibson.
My ladies, my lords, the real issue ground, first point, the test. My learned friend seems to be seeking to suggest that I'm inviting the court to apply some different test to the summary judgment test. For the avoidance of any doubt, it is the summary judgment test. It is not the strikeout test. It's sometimes referred to as bound to fail, but it's no realistic prospect of success, and the burden is on the claimants. Disclosure. We dealt with the mini-trial disclosure points in paragraph 47 MS 80 of our case. There's no need to turn it up, my lady, but two references. The first is to the claimant's written case at MS 329, paragraph 151, where they say, accordingly, the claimants do not need to rely on the possibility of future disclosure in order to establish that their claims against Vedanta are not bound to fail. Second reference we give is from Shell, and it's Lord Justice Simon at paragraph 122, MS 3353, where he said, although the claimants make a further point that it is illustrative of what may emerge on disclosure, the difficulty is that jurisdiction is founded on a properly arguable cause of action and not on what may or may not become a properly arguable cause of action. And we respectfully invite you to have regard to that, and also to the Chancellor's words dealing with the Macorba point at paragraph 182, MS 3370 of his judgment in Shell. My Lord Briggs's point about applications for disclosure, there was an application for disclosure in Shell. It is discussed at paragraph 106, MS 3351, and paragraph 122, MS 3353 of the judgment. I'm informed that the claimants made an application under CPR 3114 for all the documents referred to in the statement of claim and for the full version of the Shell control framework. In Unilever, there were requests for documents which the defendants answered in part, and some documents were provided, others were not provided. And in Unilever, the claimants relied on the fact that various documents requested and had not been provided, making similar arguments to those put before the court today. There has been no application for disclosure of any documents in this case. My lady, my lords, of course, that's perhaps not surprising when one hears how my learned friend puts his duty owed, of course, to the claimants. In a sense, he doesn't need documents, because if this duty exists in law, it's both a control duty, it's also, as I understand it, an omission to control duty, either the policies are adequate, in which case there's a failure to ensure that they are implemented, or they are inadequate, in which case there may be some direct, in which case there's a failure at that level. It's put in both ways. So if this duty exists in the broad way in which he's putting it, he doesn't actually need any documents, and we rely on that in support of our general submission that it is not arguable and is incoherent. If he wants to look at documents and policies, many of them, and one can Google them, water policy, for example, that he took you, is on the website. These are publicly available. My Lord Wilson asked about where this evidence is and where it's most helpfully explained. In the following places, my Lord, the Appendix 1 to our case, which we've updated with the MS references, identifies every paragraph of the pleading and every type of evidence that my learned friends rely on, and references the evidence in response to it and the document. The SDR document that we've given you with the references does exactly the same thing, and the short point on the SDR that you were taken to is that when one puts it in context, reads the segments in their proper context, in the context of a proper understanding of the framework, and there's no credibility issue in relation to this or dispute of fact, all of those statements in broad terms are descriptive of the group sustainability framework, and that is evident and is explained simply by reference to the documents themselves, and I rely on it, and I invite you to read it and to read the extracts in their proper context. For example, services being provided in relation to the sustainability framework worldwide by Vedanta India, a company in the group, is explained, and that my Lady Black raised a point, and that is to be found at paragraphs 56 and 57 of our case, MS 84.
You say Appendix 1 is now revised, is it? Because when I looked at it, I could see your answers to it, and I could see the pleadings, but I couldn't see a reference to the actual documents.
Yes, they are in the footnotes.
Makes the reference to the actual documents. Is that right?
Yes, the footnotes to that.
Did I have a hard copy?
You have. I asked you to be given it last night. We'll ensure that another one is made available.
Certainly been emailed.
Yes, it's been sent by email, but we'll make a hard copy available.
Thank you.
And as I say, there's also a document which takes the extracts from the Sustainability Development Report and puts...
Thanks very much.
Shell and Unilever, appreciating, of course, that those cases are under appeal, we do rely on the approach taken by the Court of Appeal in both of those cases, subjecting the evidence to critical analysis. It is of interest for the Court in my submission to see how, for example, very similar submissions were dealt with by the Court of Appeal in relation to, for example, what was known as the One Unilever Operating Framework, a framework pursuant to which all the Unilever subsidiaries were required to ensure that they were, and are required to ensure that they are implementing policies, reporting. All the similar types of arguments were made, and those frameworks have all been put in context in their evidence, in their proper regulatory context, and identifying, for example, the different obligations on listed companies that are listed on the London Stock Exchange. Secondly, in relation to Shell, we respectfully adopt Lord Justice Sales's, if I can put it this way, relegation of Chandler. It is helpful guidance. It does not constitute a new form, a category of parent company liability, and I've taken you to the facts so you can see what were in my submission the legally significant facts which led Lady Justice Arden in that case to find the requisite proximity. and the requisite and the assumption of responsibility. My learned friend, I've made my submissions in relation to Chandler, and where we submit that that framework is being erroneously applied to this case, and indeed to all these parent company cases. So my learned friend now says, well, this is a control case. Simply saying it's a control case doesn't take you anywhere, as the Court of Appeal identified in both Unilever and Shell. What you're looking for is, as Lord Justice Sales described it, is a management takeover of the relevant activity, a substantial, significant degree of control of the relevant activity. This is, if I may say so, critical to the evaluation of the evidence of this case, because the relevant activity is not some discrete aspect on which there might be particular emails or management decisions. It is the mining operations of KCM in their entirety, because it is the mining operations on the claimant's case that have been responsible for the emissions upon which they rely for the damage to land and personal injury. And therefore, it is possible, in my submission, and indeed the court can, look at the evidence of the framework, look at the evidence which is not capable of being disputed as to the way in which KCM operates as a subsidiary under the framework, in order to determine that the argument that Vedanta, with its 19 employees, forgive me for repeating that, has in fact assumed a responsibility to those living in the vicinity of KCM's mine, and, my lady, it's not inter orem, it is the case that's alleged, in effect, has assumed responsibility to all those living in the vicinity of operations in many countries worldwide. The additional documents that are relied on, I classified them yesterday as the Category 1 and Category 2 type of evidence. Category 1 I categorized as the general arguments in relation to the framework, and that's one way they argue for this proximity. The other is relying on specific documents, financial assistance, I dealt with that, and the management agreement and the shareholders' agreement. And I say again, how can it be said that entering into an agreement to provide services for a limited sum as an independent contractor can arguably give rise to a duty in respect of the entirety of the mine's operations? And this, if I may say so, is one of the dangers inherent in my learned friend's approach to all of these arguments. He takes individual items, throws them all together as, and you see this in Mr. Day's witness statement, yet more evidence, as it's put, of direction and control. And it's all treated in some holus-bolus way. If one takes the framework, if that doesn't give rise to a duty, it can't give rise to a bit of a duty. That goes in the zero column, if I could put it like that. One then looks at these different arguments said to justify a duty, and in my submission, when you look at them individually, there is no conceivable basis upon which the law could attach responsibility in those situations. So, my lady, we do rely on the degree of control that one is looking for, arguably, as described by the Court of Appeal in Shell and by the Court of Appeal in Unilever. But we are entitled, because this is a jurisdiction case, and the claimant has to discharge the burden of demonstrating realistic cause of action on the basis of the pleading. It's not taking a pleading point. It's perfectly reasonable to take that as the claimant's position. It's by reference to that document that he has to demonstrate that there is a real issue. Statutory duty, we don't have time to go to it, but Mr. Mwenwe's opinion in relation to each of the statutory duties has to be read in the context of his report as a whole. Throughout his report, he discusses Chandler, discusses the duty, in that context says that if the facts and matters and allegations and arguments in paragraph 79 through to 85 of the particulars of claim are established, then there will have been, as he puts it, an assumption of responsibility. He doesn't suggest that assumption of responsibility has any different meaning under Zambian law than it would in the juridical framework in which it is discussed in the common law cases. There's no attempt to distinguish the two, and under each statutory duty, he uses the same essential language, provided the assumption of responsibility and so on that's alleged is established, then it's arguable or tenable that there may be a duty. And that language is reflected in the pleading itself, which simply says, as you've seen, in light of the matters pleaded above. There's no suggestion that it's some of the matters or just some of the facts or just the facts. It's the matters as well, which includes the allegations. And if that gives rise to a degree of uncertainty and incoherence, in my submission, that is a good example of not overcoming the realistic prospect of success hurdle. So far as forum is concerned, one point, if I may, OJSC, and my Lord Briggs picked up on the point briefly. We respectfully submit that Mr. Justice Leggett's dictum at paragraph 10, MS 3323, that there is no reason why the claimant should be expected or required to relinquish that right to sue in order to avoid duplication proceedings, has to be treated with caution in the light of, in particular, Lord Gough's comments, for example, in Spiliada, where even on a forum non-conveniens application, he made it clear that there's no presumption in favour of England just because the claimant can sue the defendant as of right in England. The forum issue is a different issue, and we would say a fortiori with the service out case. The reference for that is at paragraphs 474B, 476F to 477F, MS 5456 to 9. My Lord Wilson's question, which no is our answer to your question. My Lord, it was about state parties in the context of the International Covenant on Economic, Social and Cultural Rights. Does it include the court? We respectfully say no. There's no obligation on this court to give legal effect to this covenant, or still less comments.
No, well, that's a different point.
I see. Well, the quote from that part of the submission is referring to comments from the convention.
Yes, quite.
My Lord asked about the criminal sanctions under the various acts. I said that there were criminal sanctions. That is correct. There are criminal sanctions under Section 5 of the Mines and Minerals Development Act. That is not in the bundle, but it's referred to in Chief Justice Sakala's report at MS 1220. There are also criminal sanctions under the Environmental Management Act, which are in the bundle, referred to at MS 3046 to 3049, a fine or a term of imprisonment up to 7 years. Access, 2 points, if I may. The judge did not, in fact, refer anywhere in his judgment, and nor did the Court of Appeal, to Lord Gough's, the sections of Lord Gough's speech where he referred to the funding issues that I took you to. Interestingly, Mr. Justice Coulson simply refers to the real risk that the claimants will not get justice. He doesn't actually refer to substantial justice. The Court of Appeal do refer to substantial justice, but neither refer to the specific sections of Lord Gough's judgment that I took you to. That, my lady, is that. Thank you.
Well, that's not bad. I do tend to go by the clock on my computer, which is always a bit faster than the clock on the wall, which is usually misleading, even when it's going. You're very lucky that it's going. Well, we're grateful to everybody for having compressed their oral arguments into a much more economical and appropriate space than the written documentation with which you've supplied us. We will now go away and see if we can work out what the answers are. Thank you.